Hello, everyone, and welcome. I'm Jennifer Smith with American Life Regional Center, and today I'm pleased to be joined by immigration attorney Simone Williams, founder and managing partner of Williams Global Law, and a nationally recognized EB-5 attorney.
Thank you, Jennifer. It's always a pleasure.
Simone, as you know, there has been a great deal of discussion recently surrounding adjustment of status, or AOS, for EB-5 investors, particularly following recent USCIS guidance. Investors are asking important questions such as, can I still pursue adjustment of status? Has anything changed? Should I be concerned? So Simone, thank you so much for joining us today.
So Jennifer, before we begin, what's interesting is that we literally learned new information last week concerning this very thing. I know we're going to be discussing a USCIS memo that generated significant concern with respect to the adjustment of status process, AOS as we call it. However, recently, major U.S. employers and the technology sector have already been engaging with the administration on this very issue, and the administration appears to be softening its approach. So this is a perfect example of why investors should not make decisions based on fear or headlines alone. And, so this topic that we're talking about today is very timely and very important because there has been quite a bit of noise and misinformation. And I hope that we can help investors better understand what has changed and perhaps more importantly, what has not changed.
Absolutely. So glad that we're addressing this topic now then. So let's start with the basics for investors who may be newer to the process. Can you just walk us through what exactly is adjustment of status and why it's been such an attractive option for EB-5 investors?
Great question. So adjustment of status, or something they called AOS, is the process that allows an eligible person already inside the United States to apply for a lawful permanent residence, or what they call a green card, without having to leave the country and complete visa processing abroad. So for many EB-5 investors, this is obviously very attractive because eligible applicants may file their I-526 immigrant petition, or we call it EB-5 petition, and as well as the adjustment of status petition. And at the same time, they could apply for work and travel authorization while the case is pending. So this can provide very important benefits because investors may be able to remain in the United States, continue their lives here, and potentially receive employment authorization and advanced parole while their case is pending.
Great. So Simone, can you, understandably, there has been some concerns following the USCIS guidance updates, but at a practical level, what actually changed?
So this is probably the biggest question we're receiving right now. Several weeks ago, USCIS issued a policy memorandum emphasizing that adjustment of status is a discretionary benefit and suggesting that applicants generally should pursue immigrant visa processing abroad unless extraordinary circumstances exist. That understandably has created concern because many interpreted the memo as shifting away from adjustment of status and doing the process right here in the United States. However, and this is what we mentioned at the beginning, there has been an important development. Recent reports, including major US businesses and companies have, in the technology and artificial intelligence sectors, engaged in substantial discussions with the administration regarding the potential impact such a policy could have on employers, workers, and the U.S. economy. Those discussions appear to have contributed to the administration softening this position, which is amazing. So while the policy discussion is still evolving, the key takeaway is this, and this is what I really want to emphasize to investors who are worried about the process. Adjustment of status has not been eliminated. It remains available. And I think that what we're seeing is the administration appears to recognize the practical and economic importance of maintaining pathways that allow eligible individuals already in the United States to pursue permanent residence. I think for EB-5 investors, that is obviously very important.
Absolutely. That's helpful and reassuring. So I think many investors, have been wondering whether they should now be worried or reconsider their plans, but it sounds like investors really shouldn't be panicking.
No, definitely not. In fact, if anything, recent developments reinforce why investors should avoid making decisions based on a single headline. Even, a few weeks ago, there was some significant concern, but then last week, the policies shifted So we have to really, make sure to consult with experienced counsel so you understand what the implications of such policies can be. And the good news is that stakeholders are continuing to speak to the administration, and the conversation continues to evolve. And I think that we can see that policies can change quickly, but the law still has not changed. And that's the most important thing. The adjustment of status remains a viable option for many EB-5 investors.
That's really good news. But that being said, are there certain investors who should be especially thoughtful right now or seek additional legal guidance?
Yes. So essentially, even though, there's been pushback on the policy, I think investors with more complicated immigration histories should be very careful and seek attorney guidance. That could include people with overstays or status gaps, prior visa denials, unauthorized employment issues, or previous status violations, or even more complex immigration timelines. But I want to stress something. Even though we have to pay attention, investors who have those types of backgrounds should pay attention. This does not automatically mean AOS is unavailable for them. It simply means careful planning matters. And for many investors with strong immigration backgrounds and histories, adjustment of status really does continue to work very well.
That's really great. So at this point, what practical advice would you give investors who are trying to navigate this uncertainty?
I think that we have to recognize that immigration policy discussions are continuing to evolve in real time. And what we saw last week is a very good example of that. Initial guidance did create concern, but today reporting suggests that significant stakeholder engagement may already be influencing how these policies are interpreted and implemented. So this is why more than ever, legal guidance, experienced legal guidance is so very much important.
Yeah, absolutely. Well, Simone, this has been incredibly helpful. Thank you for bringing clarity to a topic that has understandably created a lot of questions. Simone, any final thoughts?
Absolutely. The biggest takeaway is this: adjustment of status remains available and viable for many EB-5 investors. I think, we really do want to stress that American Life is one of the oldest regional center in the country, and I know that you guys are getting a lot of calls and concerns about this very issue. But the recent developments have generally showed us that the conversation continues to evolve, and there are significant economic and business interests advocating for practical immigration pathways. So for investors and all investors, no matter what their background is, this is never a moment to panic. This is a moment for planning. And if you're in the United States and you are considering EB-5, now is the time to evaluate your options, understand your eligibility, and develop a strategy that is tailored to your specific guidance. And obviously, with proper planning, many investors will continue to have excellent opportunities to pursue permanent residence through the EB-5 program.
Wonderful. Well, thank you again, Simone. Always appreciate your expertise in this area. And thank you, everyone, for joining us. We look forward to seeing you again soon.
Thank you. Until next time, take care.